Welcome to the Deep Dive. Today, we're digging into something really crucial if you're a U.S. investor involved in cross-border debt, especially using a Luxembourg SPV.
That's right, we're talking about the Luxembourg legal opinion.
Exactly. Think of this as, well, your essential guide. We want to help you understand the key legal assurances, maybe flag some potential pitfalls, and ultimately save you some time and hopefully some stress.
Yeah, knowing what these opinions actually mean, why they matter so much, especially when things are moving fast, it's just vital. We've been looking at a lot of expert legal research on this.
And our mission today is really to pull out the must-know info for you, the U.S. investor.
Yeah.
We'll focus on that SPV's role and how it all connects with Luxembourg law.
Okay, let's jump in.
So why is this specific document, the Luxembourg legal opinion, such a big deal? Why is it foundational for U.S. investors?
Well, it really is a cornerstone of the due diligence process. Fundamentally, it's a formal assurance. You're getting confirmation from Luxembourg lawyers on key points of Luxembourg law that affect the deal.
And what sort of key points are we talking about?
It covers several critical areas. First, the SPV's legal status. Is it properly set up? Does it validly exist under Luxembourg law? That's basic but essential.
Okay, existence. Well,
Then there's its capacité and pouvoir, basically. Its legal power and its authority to actually enter into the deal. Can it legally issue the debt or borrow or give that guarantee?
can it do what it says it's going to do?
Precisely. And third, it looks at the transaction documents themselves, the ones governed by Luxembourg law. Are they legal, valid, binding, and crucially, enforceable against the SPV?
And you mentioned speed earlier. Timeliness is key here too, right? These deals often happen quickly.
Absolutely critical. These opinions are often needed right before closing, so getting them done on time is paramount. It's all about mitigating the legal risks tied to that Luxembourg piece of the puzzle.
So it's like a legal checkup, but very specific to Luxembourg law.
That's a good way to put it. It gives investors a much clearer picture of the legal landscape they're stepping into in Luxembourg.
Okay, let's talk about the SPV itself. Luxembourg comes up constantly as the place to set these up. Why is it considered such a, well, premier jurisdiction?
There are several reasons. Luxembourg has worked hard to create a very attractive environment. You've got sophisticated, flexible legal and tax systems. Plus, it's politically and economically very stable. And the government actively supports the international finance sector. That combination makes it a top choice for things like SPVs.
It sounds like a serious setup, not just a brass plate operation.
Oh, definitely. The initial capital requirements, for instance, reflect that. It's a well-regarded, solid jurisdiction for these structures.
And for a U.S. investor, what roles do these SPVs typically play in debt issuance?
They can wear a few different hats, really. The SPV might be the entity actually issuing the debt to the U.S. investor. Or it could borrow money from the U.S. investor and then lend that money on, say, to the U.S. operating company.
Like an intermediary.
Exactly. Or another common role is providing a guarantee for debt that's issued by the U.S. company directly. The specific role obviously shapes what needs to go into the legal opinion.
And the legal form of the SPV, whether it's an SA or an SARL, that matters too. How does that impact the opinion?
It does. The SA, a public limited company, and the SARL, a private limited company, have different rules under the 1915 company law, different governance, different operational stuff, disclosure requirements.
Right.
So the legal opinion needs to confirm that the SPV is playing by the specific rules of its chosen form.
This is where it gets really interesting for me, Luxembourg's legal system itself. It's this mix, isn't it? Civil law roots, Napoleonic code, but then common law influences pop up in finance.
Yes, that's a really key point to grasp.
Why is that blend so important for a U.S. investor to get their head around?
Because while the structure of the opinion might look familiar if you're used to common law, the underlying legal DNA is civil law. Concepts like enforceability, corporate benefit, or interest social and good faith, bonne foi, they're all interpreted through the lens of Luxembourg's civil code and company laws.
So you can't just assume a term means the same thing as it does in the U.S.
You really can't. Take the concept of a trust. It doesn't directly map onto Luxembourg law. They have the fiducie, but it's different. You have to rely on your Luxembourg counsel to explain what the confirmations actually mean under their system. Don't make assumptions based on U.S. law.
Especially when it comes to things like enforceability and remedies.
Exactly. Understanding that civil law foundation is crucial.
Okay, let's break down the opinion itself. What are the core components a U.S. investor should always expect to find?
Typically, the scope covers several key confirmations about the SPV. First, its basic existence. Due incorporation, valid existence, good standing. Is it real and properly set up?
The fundamentals.
Then, its corporate power, capacité, and authority, pouvoir. Does it have the legal capacity to do this deal, and has it been properly authorized to execute the documents and take on the obligations?
And that connects to its purpose, right? The objet social.
Absolutely. The opinion checks that the transaction fits within the SPV's stated corporate purpose, its objet social, as laid out in its articles. Think of that as its official, legally defined mission. It can't just do anything. It has to stick to its purpose.
What else is usually covered in that scope section?
Due authorization is a big one. Has the deal been properly approved internally?
Wow.
Usually by the board or managers, sometimes shareholders, following all the rules.
Okay, internal green lights.
Yep. Then, due execution and delivery were the documents signed properly by people authorized to sign for the SPV.
Makes sense.
And for documents governed by Luxembourg law, the opinion will state they are legal, valid, binding, and enforceable against the SPV, subject, of course, to the usual qualifications we'll get to.
Right, and if there's security involved, like a pledge.
Good point. If the SPV is granting security under Luxembourg law, the opinion will usually cover its valid creation, its perfection, that's opposabilité haute, and its enforceability.
Opposability, that sounds important. What does that mean practically?
It essentially means making sure your security right is not just valid between you and the SPV, but it's also effective against other people, like other creditors or a bankruptcy administrator. It's about making your claim robust against third parties.
Got it. So those are the areas covered. What about the specific standard opinions you actually see written down?
You'll usually see distinct opinion statements like, 1, confirming existence and status, yes, it's duly incorporated and validly existing.
Yep.
An opinion on power and authority, yes, it has the corporate power and authority for this transaction. An opinion on due authorization, yes, all the necessary internal corporate actions were taking. An opinion on due execution, yes, it was signed properly.
And the big one, the binding nature.
Right. The valid and binding obligations opinion. This confirms that, under Luxembourg law, the SPV's obligations in the Luxembourg law documents are legal, valid, binding, and enforceable again, always with certain caveats.
Are there others we should look out for?
Often, yes. You might see one saying the transaction doesn't conflict with the SPV's own constitutional documents or general Luxembourg law.
No conflict.
Maybe one on no filings consents confirming no unusual Luxembourg approvals are needed just to make the documents legal or enforceable beyond perhaps standard post-closing filings.
Okay.
And as we said, if Luxembourg law security is involved, specific opinions on its creation, perfection, and enforceability, often referencing the financial collateral law.
Now, these opinions aren't just pulled out of thin air. They rely on assumptions, don't they? What are the common ones?
They absolutely do, and it's crucial to understand them. Counsel will assume things like the genuineness of all signatures, the authenticity of documents they're given copies of.
Standard stuff.
Pretty standard, yes. Also, the accuracy and completeness of all the factual info, representations, warranties in the documents they review.
Okay.
Critically, they assume the capacity, power, authority, authorization, and proper execution by all parties other than the Luxembourg SPV.
So they assume the U.S. company and the U.S. investor are all squared away under their own laws.
Exactly. That's a key assumption. They'll also assume the documents are legal and enforceable under their own governing laws. So if a loan agreement is governed by New York law, they assume it's valid under New York law. They don't opine on that.
Makes sense. Anything else investors should be particularly aware of on the assumptions list?
Yes, usually assumptions about the absence of fraud or duress, that all parties are solvent, that the deal doesn't violate any non-Luxembourg laws.
Right.
A very important one is the assumption that the transaction is for genuine commercial reasons and provides a corporate benefit intra-social to the Luxembourg SPV itself.
We'll come back to that intra-social, I bet.
We will. And finally, they assume all necessary non-Luxembourg consents have been obtained.
Okay, so a fair number of assumptions underpinning the opinion. What about the other side? The qualifications, the limitations, the caveats?
Every opinion has them. A standard one relates to insolvency laws, bankruptcy, reorganization, that sort of thing, which can generally affect how obligations are enforced.
But you mentioned the financial collateral law helps here.
It does offer significant bankruptcy remoteness for qualifying security, which is a carve-out from the general insolvency rules. But the general qualification is still usually there.
What else?
Public policy order, public international luxembourgeois, A Luxembourg court won't enforce something if it fundamentally violates Luxembourg's core public policy principles.
Okay, a safety valve for the courts.
Kind of. Also, limitations based on equitable principles, things like specific performance, aren't always guaranteed remedies.
And crucially,
Crucially, the opinion is limited only to Luxembourg law. It will explicitly state it doesn't cover U.S. law or any other foreign law.
so qualifications around enforcing foreign judgments in Luxembourg.
Yes, definitely. How foreign court judgments or arbitral awards are recognized and enforced in Luxembourg is subject to specific Luxembourg rules.
Any other common limitations?
The principle of good faith, bonne foi, under the Civil Code. Parties have to act in good faith, and courts can review conduct. This can qualify absolute contractual rights.
Interesting.
Penalty clauses in contracts might be reviewed by a court if they seem excessive. Statutes of limitation or time bars obviously limit when you can enforce rights. And for security, perfection is key for enforceability against third parties.
And it loops back, you absolutely need a separate U.S. law opinion, right?
100%. The Luxembourg opinion doesn't cover U.S. law aspects. You need U.S. counsel for that. The whole structure relies on this chain of opinions, each covering its own jurisdiction.
Okay, let's dive a bit deeper into the Luxembourg laws themselves, starting with the company law, the 1915 law. What's key there for our U.S. investor and their SPV?
The 1915 law is the bedrock for Luxembourg companies. For an SPV, it governs things like its valid incorporation and good standing. Whether it's an SA or SARL, it needs that notarial deed to be set up. And crucially, registration with the RCS, the Trading Companies Register.
And that registration is what makes it a legal entity.
Exactly. It grants legal personality. The opinion confirms this happened correctly and that the SPV meets minimum share capital rules EUR 30,000 for an SA, EUR 12,000 for an SARL generally.
It shows that initial commitment you mentioned.
It does.
What about the SPV's power to act that objet social again? How does the 1915 law handle that?
The objet social in the articles defines the SPV's legal boundaries, what it's allowed to do. Transactions have to fit within that stated purpose.
And if they don't, what if it acts ultra vires outside its powers?
Technically, such acts could be challenged. However, the 1915 law offers protection for third parties, like you, the investor, if you're acting in good faith. Generally, the company is still bound unless you knew or couldn't reasonably have been unaware that the act went beyond the objet social.
So just because the articles are published doesn't automatically mean a third party knows the limits.
Generally, no. But the takeaway is that objet social isn't just boilerplate. It matters. The opinion relies on the transaction being within that scope.
And getting the internal approvals, the board resolutions, and so on, due authorization.
Hugely important. The decision must be properly made by the right body board for an SA, managers for an SARL following the rules in the 1915 law, and the SPV's own articles. Quorum, voting majorities, all that needs to be correct.
The opinion verifies this process.
Yes, it confirms those procedures were followed. It also looks at who has the power to legally represent the company, the directors, managers, or delegates whose appointments are published in the RCS. Once published, third parties acting in good faith can generally rely on those appointments.
Okay. And that brings us back to intra-social corporate benefit. Why is this concept so vital for SPVs, especially in group financing?
Because directors and managers must act in the best interests of their specific Luxembourg company. When an SPV is, say, guaranteeing debt for its U.S. parent, you have to ask, what's the benefit to the SPV?
Not just the group as a whole.
Right. There needs to be some tangible benefit, direct or indirect, flowing back to the Luxembourg SPV itself. Maybe it gets a fee. Maybe it gets better group financing terms itself. The management needs to have considered and documented this rationale.
And the opinion assumes they've done this properly.
Correct. The opinion doesn't judge the commercial sense, but it relies on the assumption that corporate benefit was considered. A lack of it could, especially in an insolvency, create grounds to challenge the transaction's validity.
Okay, shifting gears to contract law, the civil code. What makes an agreement valid under Luxembourg law? The basic ingredients.
Article 1108 of the Civil Code spells out 4 essentials. You need free and informed consent from everyone involved.
Consent.
Legal capacity of the parties. Can they legally make a contract?
Capacity.
A defined and lawful object. What's the contract about? And a lawful cause. Why are they making the contract?
Cause. Okay, consent, capacity, object, cause. All 4 needed.
All 4 must be present for a Luxembourg law contract like the SPV's debt or guarantee agreement to be valid. The opinion implicitly confirms these are met from the SPV side. For you, the investor, it means making sure all these boxes are ticked for your contracts with the SPV.
And once you have a valid agreement, how strongly does Luxembourg law enforce it?
Very strongly. Article 1134 of the Civil Code is key here. It says legally formed agreements have the force of law between the parties. You can't just back out easily.
Binding is binding.
Pretty much. And critically, Article 1134 also says agreements must be performed in good faith de bonne foi.
We keep hearing about good faith. How active is that principle?
Very active. It's not just about interpreting the words. It's an obligation to act honestly and fairly in performing and enforcing the contract. Luxembourg courts can step in if they think a party is acting in bad faith or abusing a contractual right.
So it adds a layer of potential judicial review beyond just the contract text.
It does. It's something U.S. investors should be aware of. The outcome might not always be strictly what the literal words suggest if bad faith is involved. But the starting point is, valid contracts are legally binding.
Let's turn to security now. That financial collateral law from 2005 sounds pivotal if the SPV is pledging assets. What's its main aim?
It's hugely important for security over financial assets, shares, bonds, cash held in accounts. Its main goal is to create a clear, efficient, and predictable system for creating, perfecting, and enforcing that security.
Efficient and predictable sounds good for lenders.
Absolutely. And the big draw is the robust protection it offers against the borrower's insolvency, that bankruptcy remoteness we mentioned. It gives lenders much greater certainty.
It creates a kind of safe harbor for that collateral.
In many ways, yes. It covers a wide range of financial instruments and cash.
How do you actually create the security and make it stick against others, achieve that opposability?
Okay, first, you need written evidence of the arrangement. Perfection, making it effective against third parties, generally requires the pledger to be dispossessed. They lose control over the assets.
How does that work in practice?
It varies. For securities or cash in an account, it might mean crediting them to an account controlled by the pledgee, or noting the pledge in the intermediary's books and restricting the pledger's access. For registered shares in the Lux company, you record the pledge in the share register.
Does it need a notary or public filing?
Generally, no. That's a big advantage of this law. No need for notarization or registration usually makes it quicker and cheaper than some other forms of security.
So that opposability is achieved through dispossession and proper recording, essentially making the pledge visible and effective against others.
Precisely. It safeguards your position relative to other potential creditors.
And if things go wrong, if the SPV defaults, what rights does the lender have under this law?
If an enforcement event occurs, like a payment default, as defined in the agreement, the lender gets powerful enforcement rights. Generally, unless the agreement says otherwise, you can act without prior notice and without needing court approval.
No court order needed. That's fast.
It's designed to be fast and efficient. Methods include appropriating the collateral if agreed beforehand, selling it privately or publicly, or offsetting cash collateral against the debt.
And that bankruptcy remoteness, how exactly does it protect the lender if the SPV becomes insolvent?
This is where the law really shines for lenders. A validly created and perfected pledge under this law is generally enforceable despite the borrower entering Luxembourg insolvency proceedings, like bankruptcy.
So the usual freezes on enforcement don't apply.
Largely, yes. The goal is to shield these arrangements from the usual moratoriums and certain clawback rules. The pledged assets, up to the value of the debt, generally don't fall into the bankruptcy estate to be shared among all creditors.
That's a significant level of protection.
It provides huge legal certainty for those lending against financial collateral in Luxembourg.
Okay, zooming out slightly, what about the securitization law or general lending rules? Could they affect a U.S. investor using an SPV for debt?
Potentially, yes. If the SPV is set up specifically as a securitization vehicle, the 2004 securitization law applies. It's a flexible framework, allows for segregated compartments to ring-fence assets and liabilities.
Can these be regulated?
They can be unregulated or regulated by the CSSF, the financial regulator, particularly if they're issuing securities to the public continuously. And if the deal falls under the EU securitization regulation, those rules apply too.
What about just straightforward lending by the SPV? Say it borrows from the U.S. investor and lends on.
Ah, yes. Lending activities need careful review. Granting loans to the public in Luxembourg is generally a regulated activity needing a license under the 1993 law on the financial sector.
But there are exceptions.
Yes. Key ones include one-off loans, intragroup loans, and loans to a restricted circle of known parties. And SPV needs to be careful. Its activities don't accidentally trigger a licensing need if it's seen as lending to the public regularly.
So the opinion needs to check this.
Definitely. Council will analyze the SPV's exact role against the law and CSSF guidance on granting loans to the public to make sure no unexpected license is required.
Right, let's switch focus now to how U.S. law and U.S. entities fit into this picture from the perspective of the Luxembourg opinion. What's the basic rule?
The absolute basic rule is the Luxembourg opinion covers only Luxembourg law. Period.
Okay, strict boundaries.
Very strict. So when U.S. companies or U.S. law documents are involved, the Luxembourg opinion has to make explicit assumptions about them.
What kind of assumptions?
Things like the U.S. company is properly incorporated and exists, it has the legal power and authority under U.S. law to do the deal, and any U.S. law documents were properly authorized and executed by the U.S. parties according to U.S. law. Similar assumptions might apply to the U.S. investor itself.
So the Luxembourg lawyers are not checking any of that U.S. stuff themselves?
Not at all. They're relying on the fact that those U.S. legal aspects are sound. How do they get comfortable with that? They rely on a separate U.S. legal opinion.
Ah, the chain of opinions you mentioned.
Exactly. Standard practice is for the Luxembourg opinion to explicitly state its reliance on an opinion from qualified U.S. counsel covering all the necessary U.S. law matters, the U.S. company's status, the validity of U.S. law documents, etc.
So the U.S. investor needs to arrange that U.S. opinion separately.
Correct. It's essential for comprehensive legal coverage of the whole cross-border deal.
And how does the Luxembourg opinion make its own limited scope clear?
It will have very clear qualifications stating it's limited to Luxembourg law and doesn't cover any other jurisdiction, including the U.S.
Explicitly rules out U.S. law.
Explicitly. And it will likely qualify enforceability outside Luxembourg and how foreign judgments, including U.S. ones, would be treated in Luxembourg courts. That's subject to Luxembourg's own rules on recognition and enforcement, conflict of laws, and, again, public policy.
So even if the SPV signs a New York law agreement, the Lux opinion only confirms the SPV had the Luxembourg capacity and authority to sign it.
Precisely. The validity and enforceability of that New York law agreement itself, that's purely a matter for the U.S. opinion and U.S. law, though Luxembourg courts would apply conflict of law rules if enforcement was sought there.
Okay, this sounds like quite a process getting the opinion itself. What are the best practices for a U.S. investor working with Luxembourg counsel on this?
Good question. First, engage early, especially if the deal is urgent. Get experienced Luxembourg counsel involved from the start.
Why early?
It lets them spot potential issues up front, maybe structuring points, maybe corporate benefit concerns, and it helps define the scope clearly. What exactly do you, the investor, need confirmed?
Clear scope from the outset.
Yes. Then manage the due diligence well. Get them the documents, prompts, corporate records, resolutions, draft transaction docs, KYC info. Be responsive.
Keep the information flowing.
And be mindful of the timeline. The opinion is often a condition precedent to closing the deal. It needs to be ready on time.
What about reviewing the draft opinion?
Crucial. You and your U.S. counsel need to read the draft carefully. Check the scope, the specific opinions, all the assumptions, all the qualifications. Does it give you the comfort you need? Raise any questions immediately.
Manage expectations too, I suppose. Some qualifications are just standard.
Exactly. Understand what's standard market practice versus something specific to your deal. And finally, coordination between U.S. and Luxembourg counsel is vital. Make sure assumptions align, timing works, no gaps are left. A no surprises approach works best.
Might need a bring down confirmation just before closing too.
Often, yes. A quick check to confirm nothing material has changed since the main opinion was prepared.
Okay, let's talk money. Getting these opinions.
Yeah.
It sounds expensive. What drives the cost?
Costs can vary quite a bit, yeah. Key factors include how complex is the transaction? How urgent is it? What's the scope of the opinion? How much needs checking? Also, the seniority of the lawyers involved, the sheer volume of documents to review, how much negotiation there is over the opinion's wording, and whether it's a formal sign-off versus just advice.
How do firms usually charge? Hourly.
Mostly hourly rates. Fixed fees or caps are less common for complex finance deals like this, but sometimes negotiable for specific parts.
And besides the lawyer's time, what other costs pop up? Disbursements.
Yes, expect disbursements. Things like official extracts from the company registers RCS, RBE, notary fees if needed, courier costs, translation fees sometimes, legal database access charges, maybe some office service charges.
So how does an investor manage this? Get an estimate up front.
Absolutely critical. Get a detailed fee estimate or an engagement letter right at the start. It should outline the scope, assumptions, hourly rates, policy on urgency billing, disbursements, and the process if the estimate looks like it'll be exceeded.
Transparency is key.
Totally. There are many excellent firms in Luxembourg, both international and local. And remember, there are also costs for setting up the SPV, ongoing admin, audits. Get clarity on all costs and keep communication open.
Now, things change fast in law and regulation. What are some recent developments, say, as of May 2025, that are relevant here?
Things are definitely moving. The CSSF, the regulator, has been busy. On DORA, the Digital Operational Resilience Act, there are updates on register submissions and aligning ICT and outsourcing rules.
Okay, tech resilient.
Crypto assets, too. With MiCA coming in across the EU, the CSSF issued guidance in spring 2025 on classifying crypto assets, client rights, security, reverse solicitation, lots of detail there.
MiCA implementation.
Big focus on AML-CFT, anti-money laundering. Enhanced enforcement and significantly all unregulated alternative investment funds, or AIFs, now face expanded reporting duties to the AED registry with new deadlines.
That could catch some SPVs if they're classed as unregulated AIFs.
It certainly could. Definitely something to check. And on ESG sustainable finance, deadlines approaching for ESMA rules on ESG fund names. Plus, the EU Commission is looking at potentially simplifying the SFDR rules.
So, regulatory updates across the board: digital, crypto, AML, ESG.
Pretty much. SPVs need to be aware, especially on the AML front, if they fall into that AIF category.
Any other notable legislative or market shifts in Luxembourg?
Well, on a practical note, there was a wage indexation increase in May 2025.
Okay.
More substantively, a major Luxembourg banking and finance law treatise came out in mid-2024, apparently with a whole chapter just on legal opinions and finance deals could be a useful reference.
Interesting.
Market-wise, securitization continues to adapt to the EU regulation, and there's ongoing scrutiny around lending by debt funds using Lux SPVs, particularly that restricted circle exemption we talked about. Is it being used appropriately?
Always evolving interpretation there.
Seems so. And finally, Luxembourg saw a successful digital bond issuance using DLT blockchain technology recently. Shows the jurisdiction is moving with the times on financial innovation.
So the takeaway is, the ground is constantly shifting. You need counsel who are right up to date.
Absolutely essential. The pace of change is fast.
Okay, let's try and wrap this up. If you had to give our listeners one key takeaway about Luxembourg legal opinions in these deals, what would it be?
I'd say it's that the Luxembourg legal opinion is truly indispensable for a U.S. investor using a Lux SPV for debt financing. It's fundamental due diligence. It provides those core legal assurances under Luxembourg law about the SPV's status, its authority, and the enforceability of the key documents. Understanding its scope, assumptions, and limits is just vital.
And it's definitely not a tick box exercise. It needs real expertise.
No, absolutely not. It's complex. You need experienced Luxembourg counsel, especially with the regulations always changing and the inherent complexity of cross-border deals.
So that leads to a final thought for our listeners to ponder. Given how intricate this all is and how fast things change, what are the really critical questions you as a U.S. investor should be asking your Luxembourg counsel, maybe questions that go beyond the standard opinion scope, to feel truly secure about your transaction?
That's a great question for investors to think about, definitely. What gives you that extra layer of comfort?
You've been listening to The Deep Dive. If this exploration of Luxembourg legal opinions was helpful, do hit that subscribe button so you catch our future deep dives into international finance and law. And for more regular updates focused specifically on the Luxembourg fund and financial sector, check out our sister show, the Luxembourg Fundcast. Thanks for tuning in.